Good afternoon, everyone. This is Dave Place. I'm going to be conducting the third Thursday webinar today on ERISA. We'll give it a few more minutes to see if other people log in. About 2-minute warning. Okay, I think we've got most of the people who registered have now logged in. We're going to go ahead and get started. First, we're going to talk about ERISA today and Medicare refunds. A little background as to who I am. My name is Dave Place. I'm the Vice President and Director at Synergy Lien Resolution Services. I took over the head of Synergy's Lien Resolution Group about 6 years ago now. The 15 years before that, I spent as an insurance company attorney, representing ERISA plans, FEBA plans, Medicare Advantage. Basically, everybody who I now fight, I was their attorney for 15 years. In short, I looked in the mirror, I couldn't stand what I saw, so I had to join the side of angels. And now I'm helping you good people hold on to the settlement dollars you've been able to create for your injury victim clients. Hopefully I can give some useful information today on how to deal with these liens. As always, if there are questions or you want more information, please give me a call, shoot me an email. Happy to provide both this presentation and additional materials on any other lien type you have questions about. Again, please reach out to us. Our goal at Synergy is to be a partner to the trial bar to help you deal with issues that are nuanced and maybe are a niche area of practice where you don't have a lot of experience. We want to add our expertise to your case. So let's go ahead and get started. Well, since Synergy is a variety of services we provide, we're going to talk about lien resolution today, which is the division I run. We also have a national pooled special needs trust that allows your clients who are on need-based benefits to remain eligible for those benefits. We can handle a Medicare set-aside issue, a very hot topic and confusing issue as well. Obviously, we do settlement planning, settlement consulting. There's no fee for that work. That's a large part of what Synergy does, and I encourage you to contact us for that to make sure your client is thinking about their financial needs over the long term rather than just buying a new truck with their settlement dollars. Asset management and attorney fee deferral is a unique program we have to allow attorneys to structure their fees to create a tax deferral structure, as well as to increase their overall net by managing it through that service. But let's get into what I know about, which is ERISA and Medicare refunds. ERISA. ERISA is the Employee Retirement Income Security Act of 1971. The big player in the recovery vendor side is the Rawlings Group. I'm sure lots of you have dealt with Rawlings in the past. They are based in Louisville, about 20 minutes outside Louisville is their campus. I hope everybody can see the screen I'm looking at, which is their large, rather Star Trek looking building in LaGrange, Kentucky. They built it a couple years ago, and here, if you can see the screen, is a picture of their campus, a 1,000-acre campus. All those parking spaces are filled with highly trained subrogation examiners. They go to work every day. Actually, I think we're having some trouble with viewing my screen. Let me make sure that everybody's able to see my screen. Okay, I think things have improved. This is the Rawlings campus. See, it's a very big campus, 1,000 square acres. They hired about 200 more employees about a year and a half ago. So now they have 1,200 highly trained subrogation examiners. They added 250,000 square feet of office space, including 75,000 square feet of subrogation training. I point this out because most law firms have a young associate or paralegal who's tasked with, quote, dealing with the liens. This is who they're dealing with. Obviously, it's not a throwaway issue. It is a huge issue. In fact, when I was in the Supreme Court for the Montanel opinion back in 2016, the court admitted that each year, just self-funded ERISA subrogation generates $1 billion. So it's a huge industry. So kicking this off to a young associate or paralegal, they may be very good at it, but they're up against a behemoth. It is not a little mom pop shop. Now, those you deal with Rawlings have probably seen this Rawlings memo. It's a 3-page memo that Rawlings sends out with every ERISA case. Now, I talk about Rawlings a lot. They're my foil. I didn't like them when I was on their side, when I was at a company now called Equion. But Rawlings is the example of Optum, Equion, Socrates, Meridian, First Recovery Group. These recovery vendors who are out there bringing dollars back in for the ERISA plan. Rawlings is just the easiest example. They're one of the biggest out there, probably the biggest out there, and quite frankly, the most aggressive. So the McCutchen memo that they sent to you is not wrong. It says that with perfect plan language, the ERISA plan gets paid back all of their money, even in front of your attorney's fees. I want to stress, their memo is not wrong. It just only tells you half the story. So we're going to tell the rest of the story. For example, their memo ends at the Supreme Court case. It was remanded to the trial court where things get much more interesting. So we're going to talk about that. But I'm sure lots of you have seen that memo. Now, the first question I often get on a phone call is, Dave, I think I have an ERISA plan. Well, it's actually pretty easy to determine if you have an ERISA plan or not. If your client is receiving their insurance through their employer, it's going to be an ERISA plan. The exceptions are if the employer is a federal government or the state government or a church. If it's a federal government, likely the plan is a FEBA plan. If it's a state government, even if it's a self-funded plan, it's going to be subject to state law. Same thing with church plans. And churches, talk about church schools, church hospitals, and the church themselves. They are also going to be controlled by state law. Now, churches, unlike state plans, can opt into ERISA. Now, I've never seen a church plan do that other than Catholic Charities. And Catholic Charities does it because, well, they're Catholic charities and they're big enough to handle it. No one else never seen any other hospital, school, or church ever opt into ERISA. And obviously, ERISA doesn't cover Medicaid, Medicare, or individually purchased policies. I've been a telecommuter attorney for almost 20 years. I've never had my employer-sponsored insurance because it's never been the state in which I live. I've always had an individually purchased policy, so I've never had an ERISA plan. Those are some simple ways to determine whether or not ERISA is a matter for you to deal with. The real question is whether the ERISA plan is fully insured or self-funded. Now, a fully insured ERISA plan is just group insurance. The employer went out and bought a policy from State Farm or Cigna or Aetna or United Healthcare, whoever. They bear the risk of paying claims. Any recoveries through subrogation or reimbursement go back to the carrier, and it's governed by state law. Now, a self-funded plan is simply a gigantic savings account. The employee and the employer put contributions into the savings account. Claims are paid out of the savings account, and subrogation and reimbursement recoveries go back into the savings account. The reason they set up self-funded ERISA plans was back in the 70s, it was a hedge against medical inflation. The unions were the big driving force in this. They thought if big companies like Ford and GM and GE had these big self-funded plans, it would keep benefits available to all the employees and premiums low. Well, 45 years later, that didn't happen. Premiums went up and everybody's benefits were cut. But that was a rather laudable goal of the ERISA plan back in the 70s. Today, it's been perverted by the insurance industry. But that is essentially how it works. And you can see, I think, why those self-funded plans have such strong recovery rates. Okay. Well, how do you deal with these ERISA plans? What's the first thing you need to do? Well, the first thing you do is get all the plan language. ERISA plans are controlled completely by the terms of the plan document. So you need to get that document. And what Rawlings and Optum are sending you is not the correct document. You need to receive the master plan document. And there's actually a statute that provides for how to request these documents. It's 29 USC 1024B4. I say that statute so often, I think it's my first name now. I'm gonna say it a million times a day. But it really is the first brick in the you need to lay in building your case to fight the ERISA plans. Now, this statute is not tied to any third-party liability. At any point, any ERISA plan member can send all this request to their plan administrator. It is a broad statute. That is really what the statute reads are the bullet points here. Our letter is a one-page letter we use. This tracks the statute. Now, I've seen these letters be 10 pages long, asking for documents beyond documents beyond documents. I know on the one hand that seems like a big brick or a big punch to land on the ERISA plan to make them respond to this discovery request, but it's not really. I take a different approach to it. I take the approach that I don't want to do any work for the ERISA plan. I don't want to give them a checklist of things to provide to me. I send the statutory document request off. Typically what happens is the plan administrator, who's in the business of running a business, they're not in business suing their employees. For instance, US Airways is the business of running an airline, not suing the airline stewards. So we get a call back or an email back from the plan administrator saying, got your request, what do you want? Happy to comply. My response is, thank you, but we're in an adversarial posture right now. It's inappropriate for us to provide guidance on how to meet your statutory obligations. Hire counsel. In short, if they want to get money from your settlement, they're going to have to work for it. They're going to have to pay an attorney. They're going to have to expend some time and effort. They're going to lose some productivity, or they can be reasonable. But their business model is to do nothing but ride on your coattails, send one letter, maybe two, a couple phone calls, and have you pay them. When I was on the other side, my monthly goal was $800,000 a month to bring in through subrogation. Never had a problem making that goal. I had attorneys who just send me checks. I had an attorney call me up. Is this an ERISA plan? Yes, sir. I guess I have to pay you. I guess you do. You send me a check for hundreds of thousands of dollars. Don't do that. Fight these things. 1024B4 document request is the first thing you need to do. You're going to want to get that out the door immediately when a client walks in, because there are penalties that attach to it. Now, this letter does not go to Rawlings or Conduent or Nginx or any of those companies. It goes to plan administrator. Nothing else triggers the statute. In fact, the last bullet point on this slide is a cut and paste from a letter from Optum. And I had a very similar letter myself when I was on the other side, a form letter sent back to the attorney saying, hey, I'm not the plan administrator, but I am happy to provide you what I have in hand. But if you want documentation, you need to send your request off to the plan administrator. Nothing triggers the statute unless you do that. The statute I keep referring to is the penalty statute. The plan administrator has 30 days to provide you all the documents required by the statute, full compliance. If they don't comply within 30 days, they become subject to penalties of up to $110 per day. Now, it's important to remember, again, the plan administrator is an unsophisticated party. I don't mean that in a negative way. I mean, that U.S. Airlines is running a big airline. They're not answering 1024 before request. They will send you what they have. Don't take yes for an answer. Say, thank you very much for the SPD. Thank you for the claim summary. I need more, I need more, I need more, I need more. There's no end to that. In 15 years, never once did any attorney in my firm or any examiner at Equion ever comply with this request. Not one single time. In fact, they don't comply with it now on the plaintiff side. We use this argument every day. The reason for that is the Rawlings, the Optums, the Equions don't have these documents in-house. They have to go to the plan to get them. And they've been told, do not go to the plan to get them. That seems ridiculous. But remember, it's a business model on their side. They don't want to give you documents that you're not going to need because you're going to pay anyway. Why bother to go through that effort providing you accurate documentation if you're just going to send a check after they send you a form letter and a phone call? So they don't bother to do it. You have to really hammer them for it. For instance, if Coventry signs up with Rawlings today, they will give them their 2018 plan language. 3 years from now, when you send a request off to Rawlings for plan language, you'll get 2018 plan language. 10 years from now, you get 2018 plan language because they'll send what they have in their system. So you need to get the actual documentation. And there's 2 reasons for this document request. One, and importantly, you need to see the master plan. The master plan document is the document that controls. What they're sending you likely is the summary plan description, which does not control. It is just a summary of the master plan. Now, ERISA requires a summary to be written, but it is not controlling. So you want the master plan has the controlling language in it. But equally as important as getting the documents is being a thorn in their side. From their perspective, they're not a law firm. Rawlings is not, Optum is not. They are a business. They are a volume business. Rawlings examiners have about 700 files on their desk. They do not have time to provide documents, to have in-depth discussions. All they're doing is sitting under the shovel and shoveling in the money that's being thrown at them by trial attorneys. So fight these things, push back on these things. This document request, if you send it off day one, they're not going to comply with it likely. And the penalties add up to about $10,000 every 3 months. Now, you don't necessarily get the full $110 a day. The court does an analysis. But the first part analysis is compliance. Did the ERISA plan comply? Yes or no? If they didn't, then the court goes in to assess how much penalties are going to be assessed. And you will see cases of $100 a day, $110 a day, $15 a day, $3 a day, depending on the actions of the plan administrator. Now, it varies from circuit to circuit, but the courts look at a variety of factors. It's not blackboardable damages. It's things like the frustration suffered by the plan member, the behavior of the plan administrator. And along those lines, it's important to remember the plan administrator is a fiduciary to the plan member. There are case after case saying they should be proactively sending full and accurate information to the plan member, not sending, as they do now, a document here. You have to hammer them for another page, hammer them for another page, another document that's undated. You don't know what you're getting. They're just doing a document game with you. The courts hate that. Now, the flip side of this is you don't want these penalties. The only way you're getting these penalties is if you sue the ERISA plan in federal court, or you counterclaim when the ERISA plan has sued your client in federal court for the subrogation. What these penalties are great for is leverage. I said it's about $10,000 for 3 months. So at the end of the case, you come back to Rawlings, say, Rawlings, I know you have $50,000 lien you want to assert. We think you have $30,000 in penalties assessed, or the plan has, for not complying with the document request. Let's start talking at paying you $20,000. Now, it'd be very nice if you get dollar for dollar exchange on the penalties. Sometimes we do. But again, it's just creating leverage. And the nice thing is the Rawlings, the Optums, the Equions in the world, they didn't screw up. They don't have to throw themselves under the bus and say, ERISA plan, I messed up. We need to take a reduction. They can say, ERISA plan, you have exposure here. Just like when you're talking to your plaintiff about liability issues. So you have exposure here. Bills are really, a bulldog attorney. He knows his ERISA stuff. He sent his document request out. He knows we didn't comply with it. Let's be reasonable here. Either waive or take a reasonable deal. That is the great benefit of knowing these ins and outs of ERISA. This is very technical, very inside baseball. For example, the ERISA Act is a 2-volume act. The part that controls their subrogation rights is 14 words. So it's pretty niche. And even the fact that the penalty is $110 a day rather than $100 goes a long way to showing your credibility. Because the statute, as you see, says $100 a day. It's a regulation that makes it $110. When I was on the other side, we always evaluated whether the attorney was asking for $100 a day or $110. Because the attorneys asked for $100 a day as a penalty, we knew they'd been to a CLE recently, hadn't paid much attention, and didn't know what they were talking about. So their credibility actually went down. So when you're threatening the ERISA plan with penalties, make sure you talk about the $110 per day. Again, they're after the easy money. What you're trying to do with all of this is raise your fruit further up the tree so Rawlings focuses on somebody else. Again, at Synergy and in your practice, we're not going to overturn ERISA. I mean, we're not going to say there's no more insurance industry in the world. It's not going to happen. Our goal, and your goal as well, is to get the best possible deal for your individual plaintiff. And these tactics are very effective at that. Now, the last thing we'll talk about in ERISA, obviously a very complex topic, is a super complex topic. We're going to split some hairs talking about the common fund doctrine and the McCutchen case. One of the point I wanted this is give you some ammunition. This is probably one of the best arguments we have right now against ERISA plans, but also to show that Synergy expertise in this area. And I love using the McCutchen case back against Rawlings because they're so happy to send me the memo. In McCutchen, I'll give you the brief facts of the case. Mr. McCutchen was airline steward for U.S. Airways. He was hurt in a bad car accident. He had a crushed pelvis. Another individual was killed. Mr. McCutchen received $110,000 in total settlement. $10,000 from the BI, $100,000 of his own UIM. He had about $67,000 in medical bills paid by U.S. Airways, and his attorney took a 40% fee. At the end of the day, the attorney took his fee, paid U.S. Airways 2/3 of their claim, and distributed about $25,000 to Mr. McCutchen. U.S. Airways said no thanks, want all of our money back, and Mr. McCutchen defended on 2 grounds. One, the idea of made whole, which is the idea the ERISA plan shouldn't get any money back until the injury victim's entirely made whole for his injuries. And the second argument was, if they do get paid back, they should at least reduce their claim by 40% to reflect attorney's fees, the same as Mr. McCutchen had to do. Supreme Court said, no way, Jose. They said reality, fairness are, quote, beside the point. At the end of this case, Mr. McCutchen was out of pocket $867. Imagine that. Depositions, trial court, district court, circuit court, Supreme Court, is out of pocket money. Additionally, the pain from his injury was never mitigated by medication. He's since passed away, but from the time of the injury till his death, he was in constant pain. And then his health insurance company dragged him through the courts. So not a very good day for Mr. McCutchen. However, as we split the hairs, common fund issue becomes important. Common fund is the equitable background principle that anybody who's going to withdraw funds from a settlement pot, the common fund, should have contributed to the creation of that fund. The calculation is often used as attorney's fees and cost, but that is not what common fund means. Common fund is a principle. It is not a number. So to overcome the principle, the language has to be exceedingly clear. And walk through how this is discussed in the McCutchen case. Justice Kagan goes on for a page and a half in the majority opinion on how an anathema it is to American jurisprudence that a non-party gets all of their money and the injured victim, the plaintiff, gets nothing. Now, she said with perfect plan language, that's just fine. That can be how it works. But she said the language has to be exceedingly clear. Like first year's contract class. I mean, really, if you can pick it apart, pick it apart. Justice Kagan, the majority, talks about the U.S. Airways language said that the U.S. Airways would be paid out of the recovery. And Kagan's question was, what does out of the recovery mean? Does it mean out of the gross recovery, which means they get paid before attorney's fees, or does it mean out of the plaintiff's true recovery, which is after attorney's fees and cost? And Kagan said, we can't determine from the language here, let's remand the case. Okay. Add to that Scalia's dissent. Now, I really love quoting Supreme Court dissents. It makes me feel like a real lawyer. So Scalia's dissent, he points out that at a lower court level, all the parties had agreed and stipulated that the language said there'll be no reduction for fees and expenses. That's pretty clear. In fact, those of you who do this kind of work have seen plan language that reads exactly like that. In fact, most ERISA plan language reads exactly like that. And the court found that inadequate. That's key. Supreme Court found that a stipulation that said there'd be no reduction for fees and expenses inadequate. They remanded the case to the trial court. The trial court level, the court said, settlements don't fall from the sky. ERISA plan, if you want to make these recoveries, you're going to have to pay your contribution through common fund. Now, again, with perfect plan language, they don't have to, but the language has to be perfect. We treat the words common fund as magic words. If they don't appear in the plan language, we argue it did not abrogate common fund, and they must reduce by attorney's fees and costs. Now, in the McCutchen case, it gets even better because they found the plan language didn't reach to UIM. So UIM came off the table. So at Supreme Court level, US Airways got $67,000. On remand, they got $6,700. Plan language matters. Fight on these things. When you see plan language that says there'll be no reduction of fees and costs, hammer them that is not good enough. It's got to say common fund. We're getting a lot of results with this argument. Obviously, it's a couple bank shots to get them to understand it. And dealing with the Rawlings or Optum first line adjuster, you may not have a receptive listener on the other end who's listening to what you're saying. You may need to escalate to a supervisor or to their legal team. But every time we escalate to the legal team, we're not wrong in our argument. And we get lots of reductions. One thing I will point out, though, so to avoid a Pyrrhic victory, is you may completely win on common fund and it not save you any dollars. And here's why. Remember I pointed out how the 800-pound gorilla doesn't read the nuances. Luckily, they don't, because on the remand here, the court said common fund is applied to the fund as a whole. Meaning, well, we don't say it means this. We say the common fund applies each individual lien, but it is a good faith reading of this remand opinion to say that the common fund is applied to the entire settlement. So for example, if the ERISA lien was $100,000, you settled the case for $1 million. You take a 40% fee, there's still $600,000 left, which allows 100% repayment to the ERISA plan. Common fund has still been applied according to this remand. Now, we don't agree with that. Rawlings options have not made that argument to us yet, I think because they don't bother to read the cases. But just be aware that on this common fund issue, it is, if you're getting a good deal, if your fee is 40% and they're often reduced by 35%, and you're in a situation like this, you're going to need to figure out, does it make sense to push harder? Because if you litigate the matter, it very well could be that you're not getting any savings on the ERISA lien, even though you win on the issue of common fund. So you're going to check those numbers and just be aware of that weakness in the argument. But again, it's not been raised by any recovery vendor at all. I just want you to be aware of it. Okay, we'll have time for, again, shoot me some emails or calls on the ERISA if you have any questions on that. Happy to share our 1024-B4 letter. Happy to share PowerPoints. Happy to have a conversation with you about individual cases. What I'm going to talk about now is Medicare refund. Now, you're not going to want to believe what I'm telling you. You're going to think you're watching QVC and I'm trying to sell you something. I felt the same way before I joined Synergy, before we developed this process, because Medicare refund process is done with CMS directly. When I was an attorney for the insurance industry, I didn't deal with CMS because they do their own collection work. I can tell you how we developed this process. I'll lay the scenario out. We developed this service about a little over 5 years ago now. When I was talking to one of our top attorneys in the lobby of his law firm, he said, Dave, I just settled a case, a little tiny case for 50 grand. Medicare's taking all the money other than my fees and cost. If I feel terrible about this, I'm going to cut a check for 10 grand in my client out of my fee. Can I do that? Sadly, the answer is no, you cannot. That is Medicare fraud. Medicare bases its repayment upon fees paid and costs paid. If you change that number, you have to inform Medicare. And all you're going to do in a situation is cut an additional check for 10 grand to Medicare, not to your client. So it's a catch-22. What are you going to do? So that's why we developed this service, because the question was, what do we do? So many attorneys, we have a bad rap, but so many attorneys actually care about their clients and want to make sure their clients are better off. And we cannot imagine a situation where we make money in a case and the injured victim doesn't. It goes against why we're doing what we do. So how do we solve that? Medicare refund service. Here's some numbers on it, but I'll explain it more in detail. Last year, this service, we were successful 82% of the time. We got back almost $1.5 million just last year. We're closing at $5 million total now since we started the process. Average refunds about 20 grand. And some refunds have been hundreds of thousands of dollars. Lots of refunds, hundreds of thousands of dollars. And some of these processes I'm going to talk about don't have any deadlines. For instance, on the screen you're looking at, the $196,000 settlement or refund, we got 3 years post-payment. I mean, they paid the Medicare file demand 3 years prior. We went back and got a $200,000 check back from Medicare. See how you're not believing me? I can already feel you're not wanting to believe me on this process. But let's talk about it. Now, I'm talking about refunds of final demand payments. This is not just refund from Medicare, but a final demand you've paid to Medicare to satisfy their final demand claim. We can work to get all or some of that back. There's 4 ways to do it: appeal, financial hardship waiver, compromise, and something called the best interest of program waiver. I'll walk you through all these pretty quickly. Appeals. Now, appeals are only useful for 2 things. Either unrelated care is included in the final demand claim summary, or they misapply the reduction statute. Nothing else goes into appeals. Not she's old, he's injured, boy, Medicare, you're being mean, boy, it's a sad case. Not for appeals. Synergy has the first 2 level appeals because they're paper appeals. We cannot handle a 3rd level appeal because it requires an appearance. And I said, even though I'm an attorney, Synergy is not a law firm, I'm not practicing. But we always say the 3rd level appeal is decision-making time. Because according to the CMS website, it's 28 weeks to get on the docket and 28 months before you get that hearing. So I remind myself, we're not talking about young, healthy people. We're talking about elderly, severely injured people who can't wait 3 years for a hearing. So I would say it's decision-making time, usually to go into the waiver compromise process. Now, one quick note on the appeal. To get back into, if you missed, there are deadlines for appeals. There are no deadlines for waivers and compromise. If you miss the deadline, just like a normal appeal, you're out. However, there are specific statutory and regulatory guidelines that allow the ALJ leave to allow you to re-enter into the appeal process. Those regulatory and statutory guidelines are all focused on issues like the activities of the agency and the individual. Is the delay caused by the agency? Was good faith being shown? And I, even though I have not tested this, I do feel fairly confident that should you leave the appeal process to pursue resolution with Medicare through a waiver or compromise, and if you're unsuccessful there, you want to go back into the appeal process. I think the fact that you're showing constant involvement with Medicare, constant effort to resolve this matter in the face of judicial economy, trying not to waste the ALJ's time, I think you have a good argument to get leave of the ALJ to get back into the appeal process. Again, that's just Dave Place. I don't have any case law supporting that, but I think you can probably lawyer that one pretty hard that you are not avoiding Medicare. You're simply trying to find another solution. Okay, moving on to waivers and compromise. Again, there are no deadlines here. We can go back at any point. In fact, a lot of our clients will go back to their QuickBooks the last 3 or 5 years and see where they paid Medicare more than $5 grand, and then we get involved and try to get the money back. Feel free to contact us on that process. But we're talking about first is the financial hardship waiver. Then we'll talk about compromises and the best interest of program waiver. They're all different statutes, different agencies involved, different processes. Nothing will ever be easy or simple with Medicare. The first waiver is called a financial hardship waiver. This is a great one for your dual eligible clients who are Medicare and Medicaid. The standard, you argue to Medicare, is that it would be against equity and good conscience to require this Medicare beneficiary to repay the Medicare final demand. Now, you've already repaid the final demand because you have to pay the final demand in 60 days from the day of the letter, and very rarely do any of these solutions happen within that 60-day time period. We always tell our clients to pay the final demand to avoid the interest, and then we'll work to get a refund. So that's why I keep talking in terms of refund. And some of these bullet points here are examples from the Medicare Secondary Payer Manual, which is the manual BCRC uses in evaluating hardships. These are specific examples of things they're allowed to consider. And I point out the second bullet point: the beneficiary spent all the money. Now, I can't believe it's a very strong argument, but it's in the manual. The beneficiary spent all the settlement money. We can't pay you Medicare. So it is a variety of things. To get the financial hardship waiver, your client will write a hardship letter. They write it, you don't write it, we don't write it. One of the cases we had was a home invasion case in Orlando, horrible case. A 7-year-old girl's birthday party was invaded by an intruder. The little girls got away. The mother was murdered. The grandmother was shot 9 to 14 times, depending on the medical report you read. Her Medicare final demand was 160 grand. We got all of her money back in 30 days on a financial hardship waiver. And it's important to note that she wrote 5 sentences in cursive on torn out loose leaf paper. It was heartbreaking, but it wasn't fancy. And she netted, after attorney's fees and costs, well into 7 figures. So she had a ton of money. But she was able to get a financial hardship waiver because, one, she was living in Section 8 housing. She was on Medicaid. And this last bullet point here, she was now responsible for grandchildren, which are, my daughter's finishing her first year of college. Kids are surprisingly expensive. Medicare understands that. So it was a great example of using a tool that most trial attorneys are aware is even out there. And we're going to put money back in the injury victim's pocket. We do that on a regular basis. For a hardship letter, we give our clients a sample letter. We give them this bullet point talking points, and we're happy to give them instructions. But simply they're writing a letter explaining to Medicare why it's a hardship to repay them. There's a variety of reasons. And they also write a hardship letter, and they fill out a Medicare form. It's called the SSA 632BK form. It is the worst form in government. When you look at that form, you're not going to believe it's the right form. The word Medicare appears nowhere on it. The form talks about the change in repayment rate of Social Security or overpayment. And the first 12 questions are about your client's fraud and obtaining the Social Security overpayment. Now again, inside baseball, you're actually allowed to skip those first 12 questions. And the rest of the form is really easy, and it's just a monthly budget. It's actually a decent monthly budget. Puts in things like entertainment costs, clothing costs. And the idea is you want to express to Medicare the extreme financial situation and hardship of your client. Now, Bill Gates is never going to get this hardship waiver because it's the client's entire financial picture. As I point out, a large settlement doesn't necessarily mean your client cannot get this waiver. So we explore that. Now, Medicare, the hardship waiver is done by BCRC themselves internally. If they don't grant a waiver, they have 3 choices: full waiver, or partial waiver, or no waiver at all. If it's a partial waiver and it's not big enough, or it's no waiver, then we can look at a next process, which is the post-settlement compromise. This is done under the FCCA, and this is done by CMS with the help of HHS attorneys, not by BCRC. Quick note though, when I joined Synergy, I thought I was going to streamline the process and go directly to CMS with these compromise requests. Because when you send the letter to BCRC, you get a letter back from them saying, we're not the right agency for this, we're going to forward this to CMS. Well, we thought we'd shortcut that process and send it directly to CMS. No, nothing's easy with Medicare. We get a letter back from them saying, we're not the right group, go to BCRC. BCRC is the letter saying, we're not that group, we're going to forward it to CMS. So it's a ridiculous circle. Excuse me. And those who deal with Medicare may not be aware, they have a 40-day turnaround time on correspondence. 40 days. So it can really cause, missing a letter here or there can really cause a significant delay. So doing the process right really speeds things along. And frankly, Medicare has gotten very used to synergy forms, and we're now getting answers on our compromises much faster, 3 months as opposed to 8 months than we used to see. But a compromise is more like you're used to writing. The whole kitchen sink goes in there. He's old, she's injured, they take care of grandkids. Medicare, it's not worth your time and effort. Medicare, you might lose. Medicare, we don't have any ability to pay in a reasonable time period. Let's make an offer. At the end of a compromise, you make an offer, unlike a waiver request. Now, typically we offer $100. Surprisingly, $100 isn't what it used to be because Medicare doesn't jump at it like you think they would. Now, they actually have accepted it a few times, but typically the email is, Dave, we won't take your $100. We'll take $30,000 instead of $50. Here's a $20,000 refund. That's typically what we see. Now, if a compromise doesn't work, and compromises are not appealable, the last effort we have is called the best interest of the program waiver. The nice thing for you is this slide is all you need to know about it. This is all the law there is on best interest program waiver. It is just an enabling statute that gives the secretary the authority to waive any claim he or she thinks is appropriate. It's a get out of jail free card. Now, we don't use this one very often. We try to keep our powder dry on it. But because we're always kind of fighting with Medicare on it. I was arguing with the regional director in Atlanta. She said, Dave, why do you keep sending me these 1862B requests? I've granted 5 of those in 25 years. We don't see them a lot. I said, well, Betty, 3 of those 5 are ours. So we're going to keep sending those. But we do keep it, to situations where one of the other processes did not work. Because, for example, Medicare doesn't know what this means. We used to have to argue with them that they were talking about waiving the interest on the final demand because the word interest appears in the statute. They didn't seem to understand that interest meant their interest, not the interest. So it's those kind of issues. But we do use it regularly. And if you have a weird case, and frankly, Medicare spawns weird cases, this is a very usable tool. But likely we can solve that problem through one of the other avenues. This is kind of a last-ditch effort. Last slide is going to be on our pricing. Bit of a commercial, but I want you guys to understand how we work and our ethos here at Synergy. We are plaintiffs only, plaintiffs all the way. My team is built of people from Rawlings, from Equion, who spent their ill-spent youth helping the insurance industry, and now we're all motivated to make sure your clients hold on to as much dollars as possible. Because of that, we built our fee structure around that ability. Our fee is, I'm going to talk about premier clients, because if you're on this webinar, it means you're interested in becoming knowledgeable in this area and getting our services. So I'm going to premier client prices. Non-premier clients pay a little bit more. But 10% is easier math for me, and I hope all you will contact us about joining this program. Premier clients pay 10% of the reduction. So we save your client $10,000. Our fee is $1,000. You'll send us $500 up front, but it's not $500 plus 10%. In the situation I talked about, where we save your client $10,000, our fee is $1,000. The final invoice would be $500 because the total fee is 10% of the savings. You just pay $500 in advance up front. If we don't save a client at least $500, we refund that money. Now, we only want liens that are probably $5,000 or bigger, so we have the ability to make some savings. But your client should always be better off coming to us. And the Medicare refund service we talked about, partially because I know you don't believe me, and partially because we really want attorneys to take advantage of that, there is no advance fee. We only get a fee if we're successful in getting a refund. Now, we won't sell air to your clients. We'll talk to them, figure out if we have a chance to get a refund. If we don't, we'll be candid and tell them that. But if we do, we'll certainly give it a try. And our refund, our fee comes out of the refund once it's obtained. Now, the refund will come back to your office, made payable to the client. So you have a chance to meet with your client again and create hopefully a walking billboard who says you're the best attorney in the world. You got him 2 settlement checks. Also, we cap our fee. We never take more than 10% of your client's walkaway dollars. By walkaway, I mean after your fees, after costs, and after repaying any lien that Synergy worked on. We'll never take more than 10% of their true net. And the last thing I point out is my case managers, my lien specialists, as we call them, they receive a bonus the more they save your client. So Synergy is motivated financially to save more for your client. The file handler is motivated to save more for your client. So you have your client, and you can be completely secure knowing we're all invested. We all have skin in the game. You can trust we're altruistically doing this because we want to help plaintiffs and injury victims, because we do. But you don't have to rely on that. You can rely on our greed. We want to make as much money as possible, and we do that by saving your client money. Again, the cool little slide about all our services. Again, please contact us about any of these. I know a lot of the issues that Synergy deals with are the complex issues that trial attorneys are stuck with dealing at the end of their case. Our job is to make your job easier. Please give us a call about any of these issues. We're happy to give some free advice out, provide some solutions so you can wrap this matter up. Give me a call, shoot me an email. I look forward to helping you and your clients. Have a wonderful day, and thank you for attending.